All right, so we're going to start with discharges. So discharges aren't, they're not so much restoring the loan to good standing as they are eliminating the loan completely. Now, I don't want to get people's hopes up. These discharges are real. They are limited in terms of their eligibility criteria. So I'm going to go through all of these. The reason why I have them up here first is because for many borrowers who are in default, it makes sense to just at least do a cursory initial review of the borrower's discharge options. If the loan can be discharged, there's really no reason to pursue rehabilitation or consolidation if the loan can just be eliminated altogether through an administrative discharge. So it's a good first step to take a look at this and see if the borrower might qualify for any of these. I do want to be clear that even though I'm talking about this in the context of federal loan default, these administrative discharges are not limited to borrowers who are in default on their loans. These discharge options are available to borrowers who are in good standing as well. So even if you get a borrower who is not in default and you think they might be eligible for a discharge, it still might be worth pursuing either in conjunction with an income-driven plan or something along those lines, or not. But these discharge options are available for borrowers regardless of their loan status. So disability discharge is a big one. And it's a tough discharge to get historically. The Department of Education has made it measurably better in terms of getting relief under this option, and they're slowly but continuing to try to improve the process here. The main standard is this. Borrower must show that they are totally and permanently disabled for either the past 5 years or expected to be totally and permanently disabled for the next 5 years, or must result in death and be terminal. And that disability must prevent them from obtaining any substantial gainful employment. Now, technically, that doesn't mean that the borrower can't work at all. They're able to work a little bit. They just have to not be able to earn, more than poverty. Realistically, however, they're much more likely to get the discharge if they are unable to work at all. There are 3 main ways that the borrower can show this. It used to be that the only way to show it was through a physician's certification. The borrower's medical doctor needed to certify on a form that the borrower met the standard as set forth in the regulations, that they are totally and permanently disabled. They can still do it that way. Borrowers can still submit a physician certification. It's a separate part of the application. The doctor provides all of their information as well as information about the disabling condition. If we do the physician certification, I usually have the borrower supplement the application with additional medical records to kind of flesh out the application a bit. But that's still an option. However, in recent years, the Department of Ed has added 2 other alternative options that for the borrowers who meet the criteria, it's a lot easier to achieve. So one is a service-related disability as certified through the VA. The VA would provide certification that the borrower is totally and permanently disabled due to a service-connected disability. They are able to produce that documentation and the VA certifies, that's it. Their loans get discharged. Similarly, if the borrower is receiving Social Security disability payments and their disability review period is 5 to 7 years or more, they are automatically granted a discharge. They just have to produce the relevant documentation, submit it with the application, and they're done. For a lot of borrowers, this makes it easier because they don't have to go through that physician certification process. The key point I want to make here, especially for the Social Security disability benefits, is that it's got to be that 5 to 7 year review period. That's going to be on the award letter. There's a couple other forms of documentation that you can get from Social Security. But that's key. There are plenty of people who are on Social Security disability who are not going to qualify for the total permanent disability discharge, even though they're receiving benefits, because their review period is less than 5 years. So if you have a borrower and they're on disability payments, but they're only getting, their review period is 1 year or every 3 years or every 4 years, they're not going to qualify. Now, you could still go the physician certification route, and the Social Security disability benefits can be used to supplement the application in terms of persuasive power, but it's not an automatic granting of the discharge in contrast to the 5 to 7 year review. So the process, there's a form that you fill out. It's submitted to NELNET, which is the U.S. Department of Education's contracted disability discharge servicer. The website is disabilitydischarge.com. Doesn't end with the discharge, however. If the borrower is granted a discharge, they've got a post-discharge 3-year monitoring period. What that means is the Department of Ed, NELNET, is going to request information about the borrower's income and possibly their disabling condition as well. If the borrower earns above the income cap, which is typically the poverty limit for a family size of 2 in their state, if they earn above that, or if they don't respond to the request for information, or if they cease to be disabled, or they go back to school, any of those conditions, the loan can be reinstated during that 3-year period. So I actually get a lot of cases where borrowers had their loans discharged and then they never responded to the department's request for information, and they get their loans reinstated. And then we have to get the loans unreinstated and redischarged. It's a bit of a process. But that's just something to be aware of when you're counseling borrowers who might be eligible for this. Another big thing to be aware of is the possible tax consequences of a disability discharge. The Department of Ed does issue 1099-C's, cancellation of debt forms, that would require the borrower to report the canceled debt as income on the borrower's tax return. That can result in a very big tax bill for borrowers who don't qualify for one of the tax exemptions. There are certain exemptions. For instance, if the borrower is insolvent at the time of discharge, their total debts exceed their total assets, they might not have to pay a tax. But if they're not insolvent and they don't qualify for another exemption, most common example is, they're not working, but they own a house that has equity. That could be a major problem. So what I typically do before we apply for the discharge, I have my client meet with an accountant to just make sure that there aren't going to be major tax consequences, or if there are, that they're prepared for them before we go forward with the discharge, because I don't want my clients to get hit with an unexpected tax bill that they can't pay and then have to deal with the IRS, because that's not going to be fun. Now, this is a federal discharge program. There are private loan discharges. They mirror the federal standard in terms of what it takes to get a discharge, but they're completely discretionary, just like most other private student loan forms of relief. So, it'll be in the promissory note if that option is offered. I know some Navient promissory notes have it in there. Some Wells Fargo promissory notes have it in there. So check the promissory note, see if it's in there, talk to the servicer or the lender, see what's going to be possible, see what documentation is required. They are real. They're worth applying for. Just know that you're not dealing with a federal discharge program. You're dealing with, again, a discretionary private program, and there's going to be tax consequences for that as well. So that's the disability discharge. Then there's a category of discharges that are related to school conduct, something that the school did to give rise to a discharge option that the borrower can then affirmatively apply for. Again, these all have applications for the most part, and so the process involves completing the application and then supplementing the application with some supporting documentation. One category of school-related discharges is called false certification. School did something to certify that the borrower was eligible to receive federal aid for this program, and they shouldn't have certified the borrower's eligibility to begin with. So one is called the ability to benefit discharge. Key points here. The way this works is the borrower at the time of enrollment in the program either did not have a high school diploma or they didn't have a GED, and they either weren't given a test by the school to test their ability to benefit from the program, or they were given a test, but there was something wrong with the test. For instance, maybe they were given all the answers. That's a common one. Or perhaps they failed the test and they were promised a chance to retake the test, and then that never happened. Another common. I see this mostly in the context of older, now closed for-profit institutions from the 80s and 90s, where they were just sort of recruiting people off the street, basically. The best thing to do is if you encounter a borrower who went to a school that you've never heard of, like one of these for-profit schools in the 80s and 90s, it's just worth it to ask them, all right, when you went to the school, did you have a high school diploma? Did you have a GED? If not, did the school test you? What happened with the test? Because they might not even know that they're eligible for this type of discharge. It's worth asking those questions because it's a discharge worth applying. You apply for the discharge. If you get it, the loan is discharged and there's no tax consequences. And they could be entitled to a refund of every payment they've ever made, involuntary or voluntary. So it's a really beneficial discharge to try for. Disqualifying status is another big one. Same type of school. It's usually these older for-profit vocational schools. The way this one works is at the time of enrollment, the borrower would not have been able to meet the legal requirements for employment in the occupation for which they were being trained. Classic example is a borrower goes to truck diving school, takes out a federal loan to do it, but the borrower is legally blind and can't get a commercial trucking license. Or the borrower went to a vocational program to be a security guard, and then the borrower has a criminal record that prevents the borrower from being able to be employed as a security guard in that state. It's a little bit of a tougher discharge to get only because, if the school didn't know about the borrower's past history or the legal disqualification, that's been used to deny people discharges before. You have to show evidence of the disqualifying condition coupled with evidence of the disqualifying statute. So if you can't find that, that could be a bar. But it is a discharge worth trying for at least. And again, to circle back to the ability to benefit discharge, it's worth asking at the initial intake if you see one of these schools, were you able to get employment in your field? If not, why not? Because that could be the basis of a disqualifying status discharge. So these two discharges, unauthorized signature and identity theft, they're really tough to prove. So just to put that out there as an initial threshold issue. Unauthorized signature under the false certification umbrella is limited to a school official, agent of the school, who effectively forged the borrower's name on a loan promissory note. That's usually where you see it. Again, it only applies to an agent of the school. It can be really difficult to prove, and the borrower has to provide pretty substantial documentation. The Department of Ed is going to want to see, the alleged forgery along with copies of the borrower's signature, many copies of the borrower's signature from the time of the signature. Compare the two. You might need to get a handwriting expert. It's tough. I've done a couple of these, couple of successes, but it's tough to get. Identity theft is even tougher. This is where a third party, someone other than a school official, signed for the borrower on a loan contract, and now the borrower is claiming, I never signed for this. It's really tough. In order to be granted, you really need to get a court verdict or a court judgment conclusively determining that the borrower's identity was stolen. And that's really, really, really hard to get. A police report is not going to be enough. You can try, but you really need to get that court verdict or court judgment. To make things even more complicated, most identity theft cases that I've encountered usually involve either someone who has left the country, is no longer here, or it's a family member, and the borrower doesn't want to really pursue the family member in court, even though there are some hard feelings. So it's a really tough discharge to get. Standard is really high. And the borrower has to jump through a lot of hoops to really realistically have a shot at this. So a couple other school-related discharges. So closed school. Just to provide some background here to these discharges, you might have heard in the news, especially in the past year or two, that there's been a bunch of stuff going on with for-profit institutions. You might have heard of Corinthian colleges. They're one of the biggest for-profit college chains. They collapsed. Their campuses closed. And a lot of borrowers were kind of hung out to dry, stuck with loans that they can't pay with a worthless degree. And Corinthian ultimately collapsed in part because they were under investigation by various law enforcement bodies for misrepresentations about career prospects and the academic strength of their programs and some other issues as well. So school-related discharges are designed to address some of those issues, but they're limited. And I'm going to put this into context. But big one here is closed school discharge. The criteria here is that the borrower must have attended a school that closed while the borrower was enrolled, or if the borrower became aware of the closure, they withdrew within 120 days of the closure. The key element here of this discharge is that it's only available to a borrower who was unable to complete the educational program as a result of the closure. This is where the Corinthian colleges issue really comes into play. So a lot of borrowers who were harmed by the Corinthian colleges closure are not eligible for a closed school discharge, for instance, because the school closed, let's say, right before they completed their program. So they got their degree and then the school closed, and now they have Corinthian colleges on their resume, and it's a totally useless, worthless degree now. They're not able to utilize career services that they were promised because the school no longer exists. And now they have this school that has this horrible reputation, but they completed their program, so they're not eligible for this discharge. Another example is something called a teach-out, where the school announces, hey, we're closing, by the way, but we're going to allow everyone to finish their degree. We're actually going to have our faculty, complete their courses at this neighboring school. You can go to this school, you don't have to pay them any more money, and you'll be able to complete your program there. It's really attractive to a lot of students because it allows them to complete their program. Unfortunately, however, if you do that, you're not eligible for a closed school discharge. You completed your program. So there's a lot of people who are harmed by the Corinthian colleges closure and other similar closures that aren't eligible for this type of discharge. Another common issue is, again, mostly with for-profits. If there's multiple campuses, and one campus closed, but the borrower can easily get to a neighboring campus, they might not be able to get a closed school discharge if they're able to complete their program at a campus. Unpaid refund is typically not a complete discharge. It's a partial discharge. The way it works is the borrower withdrew for a period of the disbursement period of the loan that was less than 60%, but they weren't issued a refund by the school for the money they paid via loans. They can try to get sort of a prorated portion of their federal loan balance discharged as a result of not getting the refund. It's difficult to prove in my experience because a lot of people who might be eligible for this didn't formally withdraw. They just stopped showing up. And so when the Department of Education conducts their investigation, they'll ask the school for their records, and the school will show that the borrower remained enrolled for the entire term. And then it's up to us to prove, all right, well, we withdrew as of this date. They stopped going to classes. Here are attendance records, yada, yada. Here's a letter that, we sent the professor, but it's tough without a formal withdrawal date. And it's only partial relief because it's only a partial refund. You don't get the whole loan canceled because you were by definition in school for at least part of that term, so at least part of that loan is. So defense to repayment, I put that at the end with no description and a question mark because it's a very new thing right now, and it's very much in flux. Some of you may have heard of it. This, again, very much related to the Corinthian colleges collapse that I was just referencing. Here's the deal. So defense to repayment, it's a clause in, it's a very brief clause that's in direct loan promissory notes, and it's also mirrored in part of the regulations that govern the federal student loan system. And the gist of the clause effectively says, if a borrower attended a school program and the school did something that gave rise to a cause of action under state law against the school because the school did something, then the borrower can assert those violations as a defense to repayment. That's essentially what it says. That's all it says. There's no specifics. There's no application form. There's no process. There's nothing really else on it. The reason why it's become an issue is because of all those borrowers who were harmed and wronged by Corinthian colleges and similar for-profit schools that collapsed, and they're not eligible for the closed school discharge or any of the false certification discharges because these discharges are so narrow. These students, or former students, have been asserting the fact that this school is under investigation by numerous states' attorney generals for violating, state law regarding misrepresentations or consumer protection. They're asserting this defense to repayment as a way to sort of say, look, this is in the contract, this is in the regs. We should be entitled to relief. We should, we're raising these defenses, and we shouldn't have to pay the loan as a result. The Department of Ed has struggled with what to do with this because there's just really no guidance, there's no process, there's no form. So this is sort of in flux right now. Where things stand is that several thousand borrowers have submitted defense to repayment requests. The Department of Education has created somewhat of a process. They've appointed a special taskmaster to review these requests while they flesh out what they're going to do with them. They've already started granting some very minimal relief to certain borrowers who attended certain campuses at Corinthian colleges. For borrowers who are applying for this, they are allowing borrowers to go into a special type of forbearance. No payments are due while the department essentially tries to figure things out. The department this past spring just completed a round of negotiated rulemaking sessions where they're trying to really hammer out details about the process, the standard, the application, what they're going to do. So this is a very much in-flux type of situation. We don't know for sure what's going to happen, who's going to be granted relief, what the final procedure is going to be, and when all this is going to happen. That being said, it's important to know that this does exist, that these conversations are happening. There is somewhat of an informal process out there already. It is available on the Department of Ed's website for borrowers who want to try for this. At the very least, they get some temporary relief in the form of a forbearance while this is being figured out. And then depending on how this shakes out, borrowers may know what to do. Or have a better sense of what to do once a procedure is finalized. But that's defense to repayment in a nutshell. A lot going on. Pay attention to the news. I think we'll know a lot more next year.